Okay, good morning, class. Today we have lit speed building. Let me give you some words that come out. You have Michael Cross, unauthorized, police record. Good morning, Cynthia.
Good morning.
You have INS, Federal Detention Center, Brooklyn, New York, Second Circuit, IJ, deportable, BIA, administrative, Section 212, deportation, discretion, writ of habeas corpus, U.S. District Court, Judge Costa, Southern District of New York, pro se. And so Louisiana is LA twice with an asterisk. You've got New York is NORC, N-O-R-K. Second Circuit is stroked out. Deportable is deport BL. Any questions, Cynthia, on any of the words?
No.
Okay, and administrative is MRT for administrate with an asterisk, and then IV. District Court is DORT, D-R-O-U-R-T. Pro se is pro se, 2 strokes. PR, long O, and then say. And then New Orleans is Norls, N-O-R-L-S. Okay, and this is going to be, Cynthia, 170 for 5 minutes. Gentlemen, let me take this time to give you some background data in this case. Michael Cross served a sentence for the possession of a loaded gun, grand larceny of an auto, and unauthorized use of a vehicle. His police record shows arrests for several other offenses, the charges for which were dropped in exchange for his guilty pleas as to these 3 charges. Upon Michael's release from prison, the INS began a deportation proceeding. He was held briefly at the Federal Detention Center in Hope, Louisiana, before posting bond and returning to his home in Brooklyn, New York. On July 7, 1994, Michael's counsel express mailed a motion to the assigned judge. The only relief sought was a change of venue so that the said proceeding would be conducted by an IJ in New York. In support of that motion, Michael's lawyer argued that in the Second Circuit, relief under Section 212 was not foreclosed to aliens convicted of firearms offenses. Thus, the venue motion, which did not seek relief under Section 212, was purely an exercise in forum shopping. Those motion papers did not arrive in time for the July 12 deportation hearing. Michael's lawyer telephoned the IJ the day before the hearing to urge a postponement in light of the motion in transit. The IJ did not postpone the proceeding and found Michael deportable, and then the appropriate order was then duly entered. At this point, Michael had 2 options for pursuing review while enjoying, in fact, a stay action. A, Michael could have then appealed the order to the BIA, thus keeping the deportation order from becoming final, and he would have enjoyed an automatic stay during court appeal from an adverse BIA finding. He chose not to do so. The majority states that he made this choice because his motion raising the request for Section 212 relief was not part of the administrative record. However, at that time, there was no motion raising a request for Section 212 relief. There is nothing in the record before us to indicate that Michael has ever made a motion under Section 212. B, conversely, Michael had the chance to petition the IJ for relief under Section 212. And had he made this election, his deportation proceedings would have been delayed and would thus have been stayed during the course of any appeals. Michael did not avail himself of this stay either, but Michael chose to petition the IJ to reopen the case so that the IJ could consider the motion to change venue and possibly to consider directly by this belated time, motion for Section 212 relief. Secondary to this motion to reopen, Michael also requested a stay of deportation, a decision that when secondary to motions to reopen is committed to the discretion of the IJ. On August 19, 1994, the IJ denied Michael's motion to reopen the case. On August 23, Michael's lawyer filed a request with the New Orleans District Director of the INS seeking a stay of deportation pending Michael's appeal to the BIA of the IJ's denial of the motion to reopen. The next day, Michael's lawyer filed papers with the BIA challenging the refusal to reopen and also requesting a stay. Some weeks later, Michael, appearing pro se, filed a petition for a writ of habeas corpus in the U.S. District Court for the Southern District of New York, asking a stay of deportation. Though a district director's denial of a discretionary stay pending appeal from an IJ's refusal to open can be challenged on habeas petition, Michael's habeas petition was premature since the INS district director had not yet rejected Michael's application. These defects in the petition, rather than lack of a lawyer, may account for Michael's appearance pro se in New York. The petition was assigned to Judge Costa, who concluded that the Southern District of New York was not the proper court in which to bring this petition, and entered an order on June 19, 1994, transferring the petition to the Western District of Louisiana. 2 days after entry of Judge Costa's transfer order, Michael filed a pro se notice of appeal of that order in the Southern District. Incidental to this appeal, Michael filed in this court a motion seeking a stay of deportation petition for review. The stay motion was initially referred to Judge Minor of this court, who granted the stay and then lifted it after Western District of the state denied the transferred petition for habeas relief. On November 23, 1994, this matter appeared on the court's pro se motions calendar. Thus, the majority issued a stay of deportation. The U.S. voiced an informal objection, noting that it did not realize the request for a stay granted and then lifted by Judge Minor was still a live issue. In response, the first order was vacated and a new order. Anything there, Cynthia?
Is there something for calendar?
I'm sorry?
The word calendar?
Calendar?
Yeah.
You can, 3 strokes, calendar. Or could you do Caldar? I don't think it'll come out. Oh, it does, Caldar, Kaldar. And then let me give you grand larceny is glars. Grand larceny is glars, Glars. Police record is plord, Plord. Oh, maybe it doesn't come out. I don't know why you can't answer that. Put that in as police record, plord. Maybe it's PLRD or prord. No. Okay. Anything else, Cynthia?
No.
Okay. And this is going to be 180. Gentlemen, let me take this time to give you some background data in this case. Michael Cross served a sentence for the possession of a loaded gun, grand larceny of an auto, and unauthorized use of a vehicle. His police record shows arrests for several other offenses, the charges for which were dropped in exchange for his guilty pleas as to these 3 charges. Upon Michael's release from prison, the INS began a deportation proceeding. He was held briefly at the Federal Detention Center in Hope, Louisiana, before posting bond and returning to his home in Brooklyn, New York. On July 7, 1994, Michael's counsel express mailed a motion to the assigned judge. The only relief sought was a change of venue so that the said proceeding would be conducted by an IJ in New York. In support of that motion, Michael's lawyer argued that in the Second Circuit, relief under Section 212 was not foreclosed to aliens convicted of firearms offenses. Thus, the venue motion, which did not seek relief under Section 212(1), was purely an exercise in forum shopping. Those motion papers did not arrive in time for the July 12 deportation hearing. Michael's lawyer telephoned the IJ the day before the hearing to urge a postponement in light of the motion in transit. The IJ did not postpone the proceeding and found Michael deportable, and the appropriate order was then duly entered. At this point, Michael had 2 options for pursuing review while enjoying, in fact, a stay action. A, Michael could have then appealed the order to the BIA, thus keeping the deportation order from becoming final, and he would have enjoyed an automatic stay during the court appeal from an adverse BIA finding. He chose not to do so. The majority states that he made this choice because his motion raising the request for Section 212 relief was not part of the administrative record. However, at that time, there was no motion raising a request for Section 212 relief. There is nothing in the record before us to indicate that Michael has ever made a motion under Section 212. B, conversely, Michael had the chance to petition the IJ for relief under Section 212. And had he made this election, his deportation proceedings would have been delayed and would have thus been stayed during the course of any appeals. Michael did not avail himself of this stay either. But Michael chose to petition the IJ to reopen the case so that the IJ could consider the motion to change venue and possibly to consider directly a, by this belated time, motion for Section 212 relief. Secondary to this motion to reopen, Michael also requested a stay of deportation, a decision that when secondary to motions on reopen is committed to the discretion of the IJ. On August 19, 1994, the IJ denied Michael's motion to reopen the case. On August 23, Michael's lawyer filed a request with the New Orleans District Director of the INS seeking a stay of deportation pending Michael's appeal to the BIA of the IJ's denial of the motion to reopen. The next day, Michael's lawyer filed papers with the BIA challenging the refusal to reopen and also requesting a stay. Some weeks later, Michael, appearing pro se, filed a petition for a writ of habeas corpus in the U.S. District Court for the Southern District of New York, asking a stay of deportation. Though a district director's denial of a discretionary stay pending appeal from an IJ's refusal to reopen can be challenged on habeas petition, Michael's habeas petition was premature since the INS district director had not yet rejected Michael's application. These defects in the petition, rather than lack of a lawyer, may account for Michael's appearance pro se in New York. The petition was assigned to Judge Costa, who concluded that the Southern District of New York was not the proper court in which to bring this petition, and entered an order on June 19, 1994, transferring the petition to the Western District of Louisiana. 2 days after entry of Judge Costa's transfer order, Michael filed a pro se notice of appeal of that order in the Southern District. Incidental to this appeal, Michael filed in this court a motion seeking a stay of deportation review and petition for review. The stay motion was initially referred to Judge Minor of this court, who granted the stay and then lifted it after Western District of the state denied the transferred petition for the habeas relief. On November 24, 1994, this matter appeared on the court's pro se motions calendar. Thus, the majority issued a stay of deportation. The U.S. voiced an informal objection, noting that it did not realize the request for a stay granted and then lifted by Judge Minor was still a live issue. In response, the first order was vacated and a new order issued temporarily continuing the stay of the original order and granting the INS an opportunity to submit a brief. After briefing, a stay of deportation was issued on January 19, 1995, pending the disposition of Michael's appeal before the 5 BIA and the parties. Question, Cynthia? On any of the words there? And so transferred, you can write TRFRD. TRFRD for transferred. You can write Western, WERN with an asterisk, Western. Let's see, deportation, 3 strokes, D and then port and then tation. And then you have Southern, SOURN asterisk, SOURN without the asterisk. You have district is strict, yes, DRIKT. Challenged, KHAJ, come back D. Premature is premature, 3 strokes. You have in fact is NFT, initial N, final FT. And this is going to be 190. Gentlemen, let me take this time to give you some background data in this case. Michael Cross served a sentence for the possession of a loaded gun, grand larceny of an auto, and unauthorized use of a vehicle. His police record shows arrests for several other offenses, the charges for which were dropped in exchange for his guilty pleas as to these 3 charges. Upon Michael's release from prison, the INS began a deportation proceeding. He was held briefly at the Federal Detention Center in Hope, Louisiana, before posting bond and returning to his home in Brooklyn, New York. On July 7, 1994, Michael's counsel express mailed a motion to the assigned judge. The only relief sought was a change of venue so that the said proceeding would be conducted by an IJ in New York. In support of that motion, Michael's lawyer argued that in the Second Circuit, relief under Section 212 was not foreclosed to aliens convicted of firearms offenses. Thus, the venue motion, which did not seek relief under Section 212.1, was purely an exercise in forum shopping. Those motions papers did not arrive in time for the July 12 deportation hearing. Michael's lawyer telephoned the IJ the day before the hearing to urge a postponement in light of the motion in transit. The IJ did not postpone the proceeding and found Michael deportable, and the appropriate order was then duly entered. At this point, Michael had 2 options for pursuing review while enjoying, in fact, a stay action. A, Michael could have then appealed the order to the BIA, thus keeping the deportation order from becoming final, and he would have enjoyed an automatic stay during court appeal from an adverse BIA finding. He chose not to do so. The majority states that he made this choice because his motion raising the request for Section 212 relief was not part of the administrative record. However, at that time, there was no motion raising a request for Section 212 relief. There is nothing in the record before us to indicate that Michael has ever made a motion under Section 212. B. Conversely, Michael had the chance to petition the IJ for relief under Section 912, and had he made this election, his deportation proceedings would have been delayed and would have thus stayed the course of any appeals. Michael did not avail himself of this stay either, but Michael chose to petition the IJ to reopen the case so that the IJ could consider the motion to change venue and possibly to consider directly by this belated time, motion for Section 212 relief. Secondary to this motion to reopen, Michael also requested a stay of deportation, a decision that, when secondary to motions to reopen, is committed to the discretion of the IJ. On August 19, 1994, the IJ denied Michael's motion to reopen the case. On August 23, Michael's lawyer filed a request with the New Orleans District Director of the INS seeking a stay of deportation pending Michael's appeal to the BIA of the IJ's denial of the motion to reopen. The next day, Michael's lawyer filed papers with the BIA challenging the refusal to reopen and also requesting a stay. Some weeks later, Michael, appearing pro se, filed a petition for a writ of habeas corpus in the U.S. District Court for the Southern District of New York, asking a stay of deportation, though a district director's denial of a discretionary stay pending appeal from an IJ's refusal to reopen can be challenged on habeas petition. Michael's habeas petition was premature since the INS district director had not yet rejected Michael's application. These defects in the petition, rather than lack of a lawyer, may account for Michael's appearance pro se in New York. The petition was assigned to Judge Costa, who concluded that the Southern District of New York was not the proper court in which to bring this petition, and entered an order on June 19, 1994, transferring the petition to the Western District of Louisiana. 2 days after entry on Judge Costa's transfer order, Michael filed a pro se notice of appeal of that order in the Southern District. Incidental to this appeal, Michael filed in this court a motion seeking a stay of deportation review, petition for review. The stay motion was initially referred to Judge Minor of this court, who granted the stay and then lifted it after Western District of the state denied the transferred petition for habeas relief. On November 23, 1994, this matter appeared on the court's pro se motions calendar. Thus, the majority issued a stay of deportation. The U.S. voiced an informal objection, noting that it did not realize the request for a stay granted and then lifted by Judge Minor was still a live issue. In response, the first order was vacated and a new order issued, temporarily continuing the stay of the original order and granting the INS an opportunity to submit a brief. After briefing, a stay of deportation was issued on January 19, 1995, and pending the disposition of Michael's appeal before the BIA, and the parties were advised that written opinions would follow. Okay, and so I wanted to give you firearm is fire with an M, firearm, fire with an M, and exercise is KPERZ, KPERZ. And this is unauthorized is un, authorized is THORZ, come back D, possession is PEGS. And this is going to be at 190, you all. 190, okay? For 5 minutes. Gentlemen, let me take this time to give you some background data in this case. Michael Cross served a sentence for the possession of a loaded gun, grand larceny of an auto, and unauthorized use of a vehicle. His police record shows arrests for several other offenses. Sorry, a little faster than 190, 200. The charges for which were dropped in exchange for his guilty pleas as to these 3 charges. Upon Michael's release from prison, the INS began a deportation proceeding. He was held briefly at the Federal Detention Center in Hope, Louisiana, before posting bond and returning to his home in Brooklyn, New York. On July 7, 1994, Michael's counsel express mailed a motion to the assigned judge. The only relief sought was a change of venue so that the said proceeding would be conducted by an IJ in New York. In support of that motion, Michael's lawyer argued that in the Second Circuit, relief under Section 212 was not foreclosed to aliens convicted of firearms offenses. Thus, the venue motion, which did not seek relief under Section 212, was purely an exercise in forum shopping. Those motion papers did not arrive in time for the July 12 deportation hearing. Michael's lawyer telephoned the IJ the day before the hearing to urge a postponement in light of the motion in transit. The IJ did not postpone the proceeding and found Michael deportable, and the appropriate order was then duly entered. At this point, Michael had 2 options for pursuing review while enjoying, in fact, a stay of action. A, Michael could have then appealed the order to the BIA, thus keeping the deportation order from becoming final, and he would have enjoyed an automatic stay during the court appeal from an adverse BIA finding. He chose not to do so. The majority states that he made this choice because his motion raising the request for Section 212 relief was not part of the administrative record. However, at that time, there was no motion raising a request for Section 212 relief. There is nothing in the record before us to indicate that Michael has ever made a motion under Section 212. B, conversely, Michael had the chance to petition the IJ for relief under Section 212. And had he made this election, his deportation proceedings would have been delayed and would thus have been stayed during the course of any appeals. Michael did not avail himself of this stay either. But Michael chose to petition the IJ to reopen the case so that the IJ could consider the motion to change venue and possibly to consider directly by this belated time motion for Section 212 relief. Secondary to this motion to reopen, Michael also requested a stay of deportation, a decision that, when secondary to motions to reopen, is committed to the discretion of the IJ. On August 19, 1994, the IJ denied Michael's motion to reopen the case. On August 23, Michael's lawyer filed a request with the New Orleans District Director of the INS seeking a stay of deportation pending Michael's appeal to the BIA of the IJ's denial of the motion to reopen. The next day, Michael's lawyer filed papers with the BIA challenging the refusal to reopen and also requesting a stay. Some weeks later, Michael, appearing pro se, filed a petition for a writ of habeas corpus in the U.S. District Court for the Southern District of New York, asking a stay of deportation. Though a district director's denial of a discretionary stay pending appeal from an IJ's refusal to reopen can be challenged on habeas petition, Michael's habeas petition was premature since the INS district director had not yet rejected Michael's application. These defects in the petition, rather than lack of a lawyer, may account for Michael's appearance pro se in New York. The petition was assigned to Judge Costa, who concluded that the Southern District of New York was not the proper court in which to bring this petition, and entered an order on June 19, 1994, transferring the petition to the Western District of Louisiana. 2 days after entry of Judge Costa's transfer order, Michael filed a pro se notice of appeal of that order in the district court. Incidental to this appeal, Michael filed in this court a motion seeking a stay of deportation petition for review. The stay was initially referred to Judge Minor of this court, who granted the stay and then lifted it after Western District of the state denied the transferred petition for habeas relief. On November 23, 1994, this matter appeared on the court's pro se motions calendar. Thus, the majority issued a stay of deportation. The U.S. voiced an informal objection, noting that it did not realize the request for a stay granted and then lifted by Judge Minor was still a live issue. In response, the first order was vacated and a new order issued temporarily continuing the stay of the original order and granting the INS an opportunity to submit a brief. After briefing, a stay of deportation was issued on January 19, 1995, pending the disposition of Michael's appeal before the BIA, and the parties were advised that written opinions would follow. Okay, so we'll get ready for your test, you all. Today you have a mock, okay? Okay, this is going to be 1 minute at 180 lit before your mock, okay? This is just warm up. Members of the jury, my comments at the conclusion of answering all of your questions should shed some light on what I have just said. It is important that the jury consider each instruction as distinct and separate from the other, but in the end to consider all of the instructions as part of the whole. I should also add that the jury should consider this an academic discussion regarding these words and their meaning as they are used in the instructions. Do not allow yourself to give more weight to the meaning of the question academically than you give to the applicability to the instructions at hand. My notes say that the next series of questions refers specifically to CALJIC 3.92 and its subsections and may have application to 3.93. I interpreted your question to be applied principally to CALJIC 3.92 and its subsections. If you have interpreted this differently, let me know. The question that has arisen is if two separate issues are both reasonable and rational, but one is more reasonable and rational than the other, are we, the jury, to treat? And then you have 180 lit, proper names that come out. Mr. Planet, East St. Louis, Planet Manufacturing, Ralph Murdoch, Mr. Murdoch, Joseph Leland, Katie Osgood, JCPenney Company, Mrs. Planet, Mrs. Barnett, Mrs. Newland, James Thrush, Julie Thrush, Chad Howard, and Julie. And this is going to be 180 lit for your mock for 5 minutes, you all. Ladies and gentlemen of the jury, I recognize that many of you are new to jury experience. As I stand here, it is not my purpose to start an argument or inflame the emotions of others. In every case, the opening statement is given in order to acquaint the members of the jury with what each of the opposing sides intends to prove. The purpose of the opening statement is to acquaint you with what I hope the evidence will prove. The opening statement is never presented in the form of an argument. That comes later on in the trial. My opening comments are presented in such a way that it is much like opening the pages of a book and looking at the preface and then the table of contents. You can look ahead and see what the general storyline will be, or in this case, what the general scheme of evidence is expected to be. It is important in cases of this nature to have an opening statement. Sometimes we don't give one because of the large number of people involved. Ladies and gentlemen of the jury, you are already acquainted with Mr. Planet, the defendant. The evidence will show that Mr. Planet has a business in East St. Louis. The name of this business is Planet Manufacturing. The business produces machine parts and resells them to other businesses in this state. Mr. Planet has owned this business for over 14 years. He has been at the same location for 12 years. The evidence will show that Mr. Planet once had 22 employees working for him. One of his most trusted employees was Ralph Murdoch. As you will remember, until yesterday afternoon before the recess, Mr. Murdoch was a defendant in this matter. The evidence will show that Mr. Planet also had another employee who was sitting in court yesterday. That employee's name is Joseph Leland. He is not present in court today, but you will see him in the gallery from time to time, and he will also be testifying in this matter. The evidence will show that Mr. Planet, at the time of this incident, had 22 employees working for him. You will be hearing from some of them during the course of this trial. Mr. Planet also had a business partner, Katie Osgood. They had been partners for 12 years. The evidence will show that Mr. Planet handled all of the manufacturing operations of the plant, while Katie stayed behind the scenes and worked as a bookkeeper accountant. She was also in charge of hiring and firing personnel. For 12 years, this was a satisfactory arrangement for both parties. I believe the evidence will show that Mr. Planet was married. His wife worked at the J.C. Penney Company for several years and was on a leave of absence at the time this incident occurred. The evidence will show that Mrs. Planet was acquainted with Mrs. Barnett, also known as Mrs. Newland. Mr. Planet was not aware that his wife knew this Mrs. Newland. The evidence will show that Mrs. Newland had a daughter by her first marriage to James Thrush. That daughter's name was Julie Thrush. Yesterday during the voir dire, when the judge was questioning each of you, you learned about Julie Thrush. The evidence will show that Julie Thrush had a boyfriend named Chad Howard. She had been dating Chad Howard for more than 10 months before this incident occurred. You will learn during the trial process that Ralph Murdoch and Chad Howard had been friends since high school. The evidence will show that Mrs. Newland was opposed to her daughter's relationship with Chad Howard and had tried to convince Julie to break up with him on more than one occasion. Julie did not heed her mother's advice. The evidence will show that Mrs. Newland had confided to Mrs. Planet that she was afraid of Chad Howard. She was also afraid for her daughter Julie's safety when she was with Chad Howard. The evidence will show that Chad Howard attempted to turn Julie against her mother and other family members. As you learned yesterday when the judge was questioning you, Chad Howard had been on parole for the last 2 years. Because of previous parole violations, he has worn an electronic surveillance bracelet in order to inform law enforcement authorities of his whereabouts at all times. The evidence will show that on the night that Julie Thrush was murdered, Chad Howard's electronic bracelet failed to transmit his whereabouts. In other words, he was out of range for the normal surveillance techniques to work. The evidence will show that Chad Howard's whereabouts on the night of June 4 were not known. He failed to notify his parole officer where he had been. When he was apprehended by the police, he said that he had been out drinking and fallen asleep in the back of a pickup truck which had been driven out of range of surveillance monitoring. We have yet to find a witness who can back up his alibi. The evidence will show that at one time, Chad Howard worked for Mr. Planet in the shipping department. He was fired after 4 months on the job for repeated tardiness. The evidence will show that Chad Howard and Ralph Murdoch both had contact with Julie Thrush on the night of her, and then this will be 1 minute at 200 jury charge for practice, okay? 1 minute. You must decide the case for yourself, but you should do so only after a discussion and consideration of the case with the other jurors. When you retire to the jury room, you will choose one of your group who will preside over your deliberations. As jurors, you have a duty to consult with each other and to deliberate with a view to reaching a verdict, if it can be done without violence to personal judgment. No one should surrender his or her honest view as to the weight or effect of the evidence solely because of the opinion of the other jurors or for the mere purpose of returning a verdict. Verdict forms have been prepared for your use. When you have reached an agreement as to your verdict, the presiding juror will date, fill in, and sign the verdict form to reflect your verdict. You should then inform the bailiff of the fact that you have reached your verdict, but not the nature of the verdict. You will then return with your verdict to the courtroom. A verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree with that decision. In other words, and so we have your 200 jury charge, proper names that come out. You have none, okay? This is going to be 200 jury charge with no proper names for 5 minutes. Ladies and gentlemen, I will now tell you the rules that you must follow to decide this case. I will instruct you on the law. It is your obligation to follow the law. It is also your duty to determine the facts. You must determine the facts only from the evidence produced in court. You should not speculate about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned about any opinion you may feel I expressed about the facts. You are the sole judges of the facts. You must take into account all of my instructions regarding the law. You are not to pick out one instruction or part of one and disregard the others. However, after you have determined the facts, you may find that some instructions do not apply. You must then consider the instructions that do apply along with the facts as you have found them. Decide the case by applying the law and these instructions to the facts in the case. To reach your verdict, you may consider only the testimony and the exhibits which were received into evidence. There are some things that are not evidence, and you may not consider them in deciding what the facts are. I will list them for you. 1. Arguments and statements by the lawyers are not part of the evidence. The lawyers are not witnesses. What they have said in their opening statements and their closing arguments and at other times is meant to help explain the evidence, but it is not part of the evidence. If the facts of the case as you remember them differ at all from the way the lawyers have stated them, your memory of them controls. 2. Any questions and objections by lawyers are not evidence. Lawyers have a duty to their clients to object when they think a question is not proper under the rules of evidence. You should not be influenced by the objections nor by the court's ruling on them. 3. Matters that have been excluded or stricken or that you have been told to disregard are not evidence and must not be weighed by you. If testimony or exhibits have been received just for a limited purpose, you must follow the limiting instruction I gave to you. 4. Anything you may have seen or heard when the court was not in session is not evidence. You are to decide the case just on the evidence received at the trial. A witness who has some type of special training, education, or experience in a certain science, profession, or calling may be allowed to state an opinion he may have on the subject and also state an opinion he may have of the case, but you are not bound by such an opinion. To find the belief and weight to be given such opinion evidence, you may weigh the schooling, the work history, and the knowledge of that witness, the reasons given for the opinion, the source of the witness's information, as well as the factors I gave you for weighing the statements of any other witness in this case. I will now tell you more rules of law you must follow to decide this case. I will tell you more about some of the legal terms later in the instructions. 1. If you find that the defendant was not negligent, or if you find that the defendant's negligence did not cause the plaintiff's injuries, your verdict must be for the defendant. 2. If you find that the defendant was negligent and that his negligence was the cause of the plaintiff's injury, then you should weigh the defense of contributory negligence. Later on, I will tell you the rules of this defense and when it may be utilized. You may find it does not apply in this case. Negligence is the failure to use reasonable care. Negligence may be shown through action or lack of action. A person is negligent if he fails to act as a reasonably careful person would act when confronted with the same set of facts. Fault is liability or legal obligation for an injury. Before you can find a person at fault, you must find that their negligence and/or assumption of the risk was a cause of the plaintiff's injury. More than one person may be at fault. The fault of one person may be greater than that of another. The relative degrees of any fault of the parties are to be stated as percentages of the total fault after weighing all of the evidence. The total fault of the case is 100%. More than one person may be liable for causing an injury. A defendant whom you find to be at fault may not avoid liability by alleging that some other person, whether or not named as a defendant in this case, helped cause the injury. The driver of a boat has a duty to make sure that proper lookout is kept from this boat at all times. A proper lookout is one that is constantly kept by a prudent person with appropriate training. The defendant claims that the plaintiff assumed the risk. A person assumes the risk of injury when he has knowledge of a certain risk, is aware of the extent of the risk, and freely subjects himself to the risk under conditions that show he is willing to accept that distinct risk. The state of mind and conduct of jurors at the start of their deliberations are matters of great concern. It is rarely productive or good for jurors as they enter the jury room to state their opinions on the case. When jurors do that at the outset, their sense of pride may be aroused and they may hesitate to change or recede from an announced position if shown that it is wrong. Remember that you are not partisans or advocates in this case. You are the fact finders. And we'll get ready for your Q&A. (225) 1-minute practice. Mrs. Mason, I believe that you are the respondent in this cause. Is that correct?
Yes, sir.
You are the former wife of James Trenton Mason?
Yes, sir.
And you obtained a divorce from him in 1969?
Yes, sir.
And subsequent to your obtaining the divorce, can you tell the court whether or not he remarried?
Yes, he did.
Was the person that he remarried the same person mentioned in your adultery case?
Yes, sir.
And to your knowledge, do he and his present wife continue to reside together as man and wife?
As far as I know.
Were you aware that she had children by a prior marriage?
Yes, sir.
And were you aware of the fact that he is supporting and educating those children?
Yes.
Now, you understand that he has brought this action to eliminate from the former order of the court the 18-year-old child who is deceased, having died in an automobile accident. You understand that?
Yes, sir.
And also, he is asking the court to eliminate the support for the 18-year-old child. You understand that?
Yes, sir.
Is there any issue that you had one child who died as a result of injuries received in an automobile collision?
Is there an issue? No, that did happen.
That did happen. And then on your 225 Q&A, you have Bart Babbage, Ed's Trading Company, Adam Indeed, Eden Place, Blinn, Texas, Johnny Quick, Barnes Factory, Barnes, Refridges, Due Day, Bill Higgy, Billy, Higgy, Andy, Bendel, Mole, EMS, Woozy, Lindsay, Kenner. And this will be your 225 Q&A for 5 minutes. And it starts in the beginning, okay? Good afternoon, sir. My name is Bart Babbage, and I represent Ed's Trading Company. Has your attorney explained to you what a deposition is?
Yes.
Have you ever been deposed before?
No, I don't believe I ever have.
Have you ever testified in court before?
No, I sure haven't.
Do you understand what perjury means?
Yes, I know what perjury means.
All right. What do you understand perjury to mean?
Well, it is like,
Do not be embarrassed if you do not know what it means.
I'm not sure what it means.
What did you do a minute ago when you raised your hand?
I swore to tell the truth, the whole truth, and nothing but the truth.
Do you agree to tell the truth today?
Yes.
If I ask a question that you do not understand, please stop me and I will rephrase the question, okay?
Fine.
State your name, please.
My name is Adam N. Deeb.
Mr. Deeb, what is your residence address?
1427 Eden Place, Blinn, Texas.
What is your date of birth?
I was born on March 3, 1953.
So that makes you 38, is that correct?
That is correct.
Please describe for us briefly your education.
Not much to describe. I dropped out of school in 1966.
What was the last grade that you completed?
9th.
Why did you leave school at such an early age?
My old man split on us when I was a kid. I was getting tired of watching my mom work herself to death for us. I was the oldest of 3 children, so I felt I ought to quit school and help the family out.
What was the job you first took after dropping out?
I was a bag boy at the Johnny Quick, after a while, a checker.
Johnny Quick is a supermarket in Blinn,
Yes, it is the best supermarket in the area.
and you were employed at Johnny Quick for how long?
6 years. Then I took a job at the Barnes factory.
What did you do at Barnes?
There I was, an appliance packer.
What exactly is an appliance packer?
As the appliances come off the inspection line, you wrap them in packing material and place them on the belt to be put in boxes.
Did you enjoy this job?
It was okay. I mean, it paid the bills.
Did you expect to remain in their employ for a long time?
I am not qualified to do nothing else.
All right, I want you to explain to me what the nature of I would like you to explain to me how the accident occurred.
Well, it was Refridges' due date. I was waiting at the end of the conveyor belt.
Let me stop you here and ask you what Refridges' due day is.
That's the day we packed the ice boxes.
I understand. Please continue.
Well, I'm having some trouble with one of the suckers, and I guess it was taking more time than usual to wrap. My back was to the belt, and I didn't see the next fridge. It fell off of the belt and right on top of me.
What were you feeling at this time?
Are you serious?
Please answer the question.
I was in extreme pain. These things are very heavy.
What happened next?
Bill Higgy was working the safety switch that day, and when he heard me scream, he tried to slow and stop the belt.
Was Bill able to stop the belt?
Not at first. He was a little shook up, and he pulled the switch the wrong way at first.
What was the result of that?
The belt began to speed up. 2 more of those big jobbers fell on me.
What happened next?
Then Billy got the belt stopped.
Where were you at this time?
I was under 3 large appliances.
What was your condition at this time?
I was hurting all over. I kept going in and out.
What do you mean by going in and out?
Blacking out and coming to, you know.
Is this the point when Higgy and some other workers came over to attempt to assist you?
Andy, Bendel, and the Mole came over to help me. Higgy was calling the emergency.
Did the EMS unit arrive soon?
At the time, I was very woozy and had no idea of time. The guys told me later that it only took about 10 minutes.
What did the medics do when they first arrived?
They checked my heartbeat and my eyes with a little light.
Did they take you to the hospital?
Yes, they stuck me on a stretcher and put me in the back of the van. When the siren came on, I was very out of it. It seemed like a dream sometimes.
What is the next thing that you clearly remember?
Waking up in the hospital. It was the worst moment of my life. I felt drained. I was tired and I was thirsty. I saw a water pitcher on the night table next to me. I reached to get me a drink, but nothing happened.
Nothing happened? What do you mean by the statement, nothing happened?
I couldn't get a drink of water
Why not?
because they cut my freaking arm off.
Was there a nurse or an orderly in the room with you?
Not until they heard me scream. Then the room filled up.
What do you mean?
Everybody and their brother comes in to catch a sight of the geek with one arm. I was screaming and crying like a little girl. I couldn't accept my arm was gone. I kept saying, it's not right, damn it. It's not freaking right.
What was the hospital staff doing at this time, Mr. Deeb?
They was holding me down. I was going nuts. They were on top of me, grabbing at me.
What happened next?
This nurse comes at me. She was a big, old, ugly thing. What a scary broad. Anyway, she sticks me with this long needle and I'm out cold.
When you came to, were you aware of this prior incident taking place?
It was like waking up from a nightmare, only I knew it really went down.
Was anyone in the room when you awoke the second time?
Yes, Lindsay was in the room with me.
Who is Lindsay?
Lindsay Kenner. She was the shrink assigned to my case.
Did the two of you discuss your case?
Well, I wanted to play the tough guy because Lindsay is a real looker, if you know what I mean.
Yes, I do.
When she asked me,
Okay, so that concludes your mock. You all type them up. It was very fair, very good, okay? Have a good day. And you all remember to go into EV360 if you haven't already done so. There's a new link in there that you need to go to. And if you still are having a hard time, you create a username and password. I will put Jeff Moody's number in there so you can be in contact, okay? Have a great day.